Buckley v. Vallejo in 1976 was a case in which the Supreme Court of the United States upheld a federal law which set limits on campaign contributions, but ruled that spending money to influence elections is a form of constantly protected free speech. The court also stated that candidates can give unlimited amounts of money to their own campaigns. The McCain-Feingold Reform Act of 2002 revised some of the legal limits of expenditure set in 1974 and prohibited unregulated contributions called soft money to national political parties. It also prohibited contributions made from corporate or union treasury funds 60 days before an election. Additionally, increased the limit of $2,000 of individual contribution to a presidential election and congressional candidate, but could increase based on inflation.
In 2010, Citizens United v. FEC confirmed that the First Amendment prohibits the government from restricting political independent expenditures. In 2014, it struck down the limits on how much individuals and corporations could give in total to federal candidates and party committees, claiming free speech rights. It left in place the limitations per candidate.
PACs are political action committees that are allowed to raise and spend unlimited amounts of money from corporations, unions, individuals, and associations. Some nonprofit groups are allowed to contribute to super PACs without disclosing where their money came from. The most important difference between a super PAC and a traditional candidate PAC is who can contribute and how much they can give. 501c groups are groups that are exempted from reporting their contributions and can receive unlimited contributions. Section 501c of the tax code specifies that such group cannot spend more than half their funds on political activities. 527 groups are independent political groups that are not subject to contribution restrictions because they did not directly seek the election of a particular candidate. Section 527 of the tax cut specifies that the contribution to such group must be reported to the IRS.
Political contributions earmarked for party building expenses at the grassroots level or for generic advertising. Unlike money that goes to the campaign of a particular candidate, such party donations are not subject to contribution limits. For a time, such contributions were unlimited. The McCain-Feingold Act changed this.